Good morning, everybody. My name is Mike Boone, legal instructor from Blue to Gold Law Enforcement Training, bringing you a Bulletproof DUI Report Writing webinar. Glad to have you all here this morning. We're going to jump right into it here. We're gonna cover a ton of different topics today. First and foremost, especially when it comes to DUI, make sure you know your laws, your SOPs. States have different parameters on what vehicles are and what you can get a DUI in. So make sure you're aware of your laws and your SOPs. If you have any doubts, again, push it up the chain. That's why you guys make the big bucks with all those rank and stripes on your shoulders for sure. And again, this course is legal education, not legal advice. We're just again trying to make you all just aware of some of those things that can make your reports just a little bit better for the great work you guys are already doing out there. So what we're going to run through today is a report writing overview, some of the framework stuff that we teach in our report writing classes, some mechanics that are great things that make your cases legally defensible, things that will stand up in court, things will stand up in evidentiary hearings. A lot of stuff comes from our report writing class. We're going to touch on the law, just kind of the generalized framework of what most states have as far as DUI laws go. Talking about transition from a DUI investigation, from a traffic stop into a DUI investigation, and then just a few things that to look out for when it comes to trial strategies, when it comes to testifying. So let's start off with report writing overview. When we jump into this here, why the heck are we here? Like, why is this even important for us to be talking about the report writing part of this? And I will say, as being a police officer for almost 22 years, that we in this amazing chat here from all across our great country here, we do phenomenal work as police officers out there. We kick ass. Okay, we do a great job, and myself included. Sometimes we don't write it down as best as we could. We don't articulate these things that are legally significant when we do so. So that's the why we're here, right? We want to discourage filing motions to suppress, right? We don't want to give these defense attorneys any opportunities that something that legally significant took place out there, trying to suppress our evidence, make motions to drop the case completely. We don't want that. We want our stuff to stand up all the way through, ideally beyond a reasonable doubt. And we'll talk briefly about that as we go. So, when we look at this here, the question comes up, does a defendant have an automatic, no questions asked right to a suppression hearing? What do you guys think? Automatic, no questions asked right to a suppression hearing. Got my blue to gold tea bottle here this morning. And we're kind of all over the place on this one here. All right, so when we're talking about automatic, no questions asked, here's what the courts say on this here. They say that essentially the court is required to hold a, oops, sorry, we're going back here. Pushing too many buttons here, right? Hearing on a motion to suppress whenever moving papers, essentially moving papers are like documents filed with the court, to suppress whenever are sufficiently defendant specific and detailed to establish a contested issue of fact. What we mean by that at the end of the day is you got to have something, right? There's got to be something going on. There's got to be some sort of contested fact that's taking place for for them to file a motion for evidence hearing, suppression hearing type of things. You don't just get this automatic carte blanche just because we want to see if we can poke holes in some reports or see if we can convince a judge that whatever it is here, it's not a freebie, right? They've got to come up with something. And why we're here? Well, we don't want to give them any of those factors so that these suppression hearings. I've been in plenty of them in my career, and they're not that much fun. But if you've articulated your back behind it, at the end of the day, your evidence is going to hold up in court. We want to encourage guilty pleas. There's a lot of time, effort, money that goes into going to full trial, so that if we can we encourage a guilty plea with this bulletproof report on the front end where the defense attorney's like, man, these officers out there are dialed. They have anything that was legally significant, they articulated. They've met all the elements of our crime. And any evidence that they found against you, it was done reasonably under the Fourth Amendment. So we might want to take what the state offers. At the end of the day, we can get some good plea deals out of that there too. Also, our reports are how we speak with our prosecutors, right? This is our roadmap. This is the information that we give them for the great work that we are doing out there, right? They're not there with us. They don't have the time to sit there and watch all of our body worn camera. That's for sure. So this is, all the work we're doing out there. This is how we tell them what we're doing. That's a great roadmap. And then it provides a basis to fully refresh your memory for trial. These things don't happen quickly. When you make that arrest, it's not happening next week is when you get to go to trial. You know that it can be, months, years down the road as to when you actually set forth that trial date. Now you got to try to remember what you did a year ago. Yeah. I always said I like to send myself little love notes in my reports, man. Sometimes I was testifying earlier in my career. I'm like, man, I sure wish I would have told myself a little bit more about what the heck I was doing out here. Then as you progress in your career, send those little love notes to yourself or your future self that you'll thank yourself for sure, right? Email the slideshow to us. Yes, I think we can get that link, right, Rick? I believe so. Let's see. DUI tried to be suppressed late last month. They backed out last minute. Plead the case, right? Yeah, they'll try to push the issue, see if maybe the cops don't show up or some other issues. And again, they know if your stuff is dialed, they don't want to go to trial on that because you've got your reports locked in. So we'll talk real quickly about our burdens, right? Our burdens of proof out there. So when we look at reasonable suspicion, right? One of our lowest burdens. We've got a hunch, then reasonable suspicion. It just requires a moderate chance of illegal activity. That's it, a moderate chance, but it's still a burden that we have to meet. What case gives us reasonable suspicion? The seminal case out there. This one warms my heart if you guys nail this one. What case is this? Reasonable suspicion to stop a person and to pat them down. That case is, there we go. Gosh, warms my heart. One of my favorite cases for sure. We don't have time to tell the whole story now, but I went there. I went where the Terry stop happened in downtown Cleveland and I soaked it all in. And I almost had my wallet stolen, but that's a story for another time. All right. So when we look at a case here, it says in People versus Johnson, the court found that police officer had reasonable suspicion to believe the defendant was driving under the influence based on observations of the defendant's car weaving within a single lane for an extended distance. Although the officer did not witness a specific traffic offense, meaning he didn't see PC specifically, the continuous weaving over 5 or 6 miles was identified as indicative of intoxicated driving. The court said facts that might seem innocent when viewed in isolation can sustain a finding of reasonable suspicion when considered in the aggregate. And that's, as we know as police officers out there, we know that it's the T to the O to the C, right? The totality of the circumstances, putting all these pieces together is what gives us reasonable suspicion. And as the court said in this, isolated pieces by themselves sometimes are almost meaningless. But now you put them all together, that's when we have reasonable suspicion. That's what we've got to articulate. And then we move into probable cause, right? Fair probability of a crime being committed. Okay, fair probability. We got reasonable suspicion, a moderate chance of criminal activity, probable cause, fair probability of a crime being committed. Again, not a real high burden, but it's that minimum burden we have to meet in order for us to arrest a person. So what do we need to convict a person in court? And we know it's the bird, right? It's the bird, right? Beyond a reasonable doubt. And, a quick definition of beyond a reasonable doubt is the legal burden of proof required to affirm a conviction in a criminal case. This means that the prosecution must convince the jury that there is no other reasonable explanation that can come from evidence presented at the trial. Right? It's not absolute certainty, but man, it is way up there. Okay, way up there. We don't usually talk about percentages in the way we teach it here, but man, it's up there 98, 99% up there. It's really high, but it's not absolute certainty. Here is probably one of the most famous examples of inserting doubt.
It doesn't fit. If it doesn't fit, you must acquit.
The late, great Johnny Cochran, right? If it doesn't fit, you must acquit. If you guys haven't checked out, there's a new 4-part series on the O.J. Simpson trial. Man, check it out. I knew there was some stuff going on out there, but I had no idea to the depth that was going on. So a little plug there for Netflix. All right, maybe we get some kickback royalty on that. So California was not able to convict OJ, correct, of a double murder, and you can have your opinion on whether or not you think he did it, but my old agency put him in prison. Anybody know what LVMPD put OJ in prison for? What's that? Yes. We put him in prison for stealing his own stuff back. Right? We got him. He walks on a double murder, but Metro got him and put him in prison for stealing his own stuff. All right. So who's in charge of obtaining enough evidence for a beyond a reasonable doubt case? And it looks like some of you guys already jumped in on this. You, us, right? It's on us. We are the boots on the ground. We're the ones out there that are gathering the evidence, talking to the witnesses, looking at the surveillance video. Absolutely is us. Our cases are built on the first responders out there, the first people on scene, without a doubt. Okay, it's make or break. You know that. Uh, what, Tanner? Oh, man, we're not keeping score out here, Tanner. Wait, Tanner, are you same Tanner that's talking about my green screen the other day? Yeah, same one again. All right, put my stuff on the shelf. Let me set my coffee down again here on the bookshelf, right? All right, so you know we are, right? We're the ones that make or break these cases here. And then who is in charge of delivering a beyond a reasonable doubt case on behalf of the state? And you guys know that it's turned over to them, right? There it is, the prosecutor, ultimately up to the prosecutor. They are in charge of it. Yeah, they got rules of evidence and all the things they got to go by, but we've got to give them the tools. We got to give them the tools to do so. I was teaching report writing the other day, and you know here at Blue to Gold we're using a ton of new AI generated slides in our slide deck, and that's what I love about the kind of the still a little bit new technology in here. Here's how I picture this slide being made: police officer, lawyer, judge in a courtroom. Go AI, make me something cool. So we've got our officer there over there, cool. We've got our fancy lawyer, judge, all right. And then AI says, let's put the gavel down here between the cops and the lawyer. And for good measure, check out the judge's desk on top of the bench there. What is that? Bottle of whiskey and wine? Now, I'm not saying AI is not correct, but where should that stuff be? At least in chambers or underneath where it's not visible, right? So that's why yeah, is it Dayquil? Yeah, maybe it's Dayquil and whiskey, right? You never know what a judge needs. Yeah, lean. That's the new word of the day, right? He's got some lean on the desk there. Um, again, I love some AI, right? All right, so let's talk about report mechanics, right? Yeah, it does look like Sam Elliott, doesn't it? For sure. He does it all, so why not be a judge? All right, so we're going to jump into our report mechanics, right? Kind of some structural things as to what to make your reports so much better. All caps. Man, okay, yes, we do a lot of handwritten stuff out there. We still want to do, block uppercase block letter type stuff for sure. But when you're typing it out, here's me. That shows you how old I am on the old typewriter, right? When you're typing out your reports, don't use all caps, right? Don't use all caps for a few different reasons, right? One, it's harder to read, and we'll show you a couple of examples. Two, you lose the ability to have proper nouns. We'll talk about like brand name of something here, proper name. And three, it's harder to scan. You're on the stand trying to scan something for information, much harder to see. You look at the the old 2020 trying to do this here, right? It's all caps there. Look at this report here. It feels like you're being yelled at, right? It's kind of like you're being yelled at and doing so. Hard to scan, difficult to see what's going on there. Here's, uppercase, lowercase, much easier to scan information. You can find a person's name or stuff that you're looking for. Again, yeah, I'm being yelled at in this case here. I don't want to see that again. Also, yeah, uppercase, lowercase, that's what we're looking for. I observed a bottle of clear vodka near the driver's leg. Well, are we talking about a transparent fluid inside of this bottle or brand name? Is that the question? Is that clear or is it the brand clear? So just another example of why caps can be a problem in our typed reports. So don't do it. All right. Topic headings. These are phenomenal. I use these all the time in my search warrant officers reports and a lot of my arrest reports in there. It's just a great, great, great way to organize your thoughts. You'll hear it called topic headings. You'll hear it called bucket style, some other places here. Essentially, it's when you include a separate sentence before the paragraph to explain what you're about to discuss. So we call this is a pro moves out here for sure. I know our prosecutors love them. I know judges love them out there. Again, it's great stuff here. One, it just helps you to, it compels you to be more organized in your report. And we'll show you a couple examples as how to that makes it look, search incident to arrest, or what your pat down articulation is, whatever it may be in there. It's way more organized. And like I said, when you're on the stand up there trying to find your stuff, easier to scan for information. If your judge is looking at your reports trying to establish does probable cause exist, well, they can look for those things within your report and not have to dive through your whole narrative. So here's just a few examples of topic headings out there. And really, the guideline is whatever works, whatever is going to follow in that paragraph, call it that, right? Some examples, driver contact, interviews, consent to search, Miranda. Again, whatever works, just use that to call what's coming below. So here's a DUI report. Phase 1, vehicle in motion. Phase 2, personal contact. Phase 3. As you can see, the information that follows in these topic headings, if you're looking for that personal contact in that initial thing, boom, right there you can find it, no problem. Post-arrest procedures, your breath testing, again, easy to find, easy to locate again inside your reports here. Again, same style here, just kind of broken up into paragraphs. Again, much easier to find things out there. Here's an example, details for probable cause. Like I said, I've got feedback from judges that just really like this because, so they can find, what they're looking for, a nice little summary statement, details for probable cause, find that like, all right, this report's going to at least hold water when it comes to probable cause. Next is bullet points. Okay, these, my friends, are mic drops. Okay, not me, Mike. Mic drops, right? And really, when we look at this, is an effective way to justify legally significant actions. Additionally, bullet points are a great pre-report articulation tool. And I cannot emphasize that enough. You put bullet points in your report, you are going to convince other people that the conclusion you came up with is reasonable. They're going to look at this and go, oh, okay, I see why you patted this person down, or I can see why you did a protective sweep of this vehicle. You've justified these legally significant things in a way that's easy to see and understand. Few reasons for it. We're very analytical, right? We're cops. That's just how we speak. And I hope it's okay if I still say we because, I'm still part of the family, I hope, even though I'm civilian, right? But we're very analytical, right? That's just kind of, we analyze things. We're always going to know why, what's going on here. Another reason is it forces you to articulate more. And at the end of the day, articulation is key. Articulation wins cases. Articulation wins suppression hearings. Articulation allows you to win when you get sued. Okay, you articulate more, and prosecutors file them like them for motion and prep and court prep. They can see these things that are legally significant that could be challenged, some things that could be litigated, and now there it is. Okay, it's right there in front of them. So when we look at it, I don't want you to write your whole report in bullet point style. That'd be kind of weird. But when we look at that, here's some examples of here. Oops, sorry, hang on. My chat screen just got 900 times larger than it was. All right. I believe Stevens had actual physical control of a motorized vehicle because I'm going to talk about that word here in just a second. But if you all start using the word because from today, I haven't wasted your time, and it's a win for me. Because, bullet point number 1, he is the registered owner of the vehicle. I observed Hugh driving the vehicle. He was operating the vehicle on Warm Springs Road. He was the only person in the vehicle. He was in the driver's seat, and I watched as Hugh turned the vehicle off. There are 6 factors right there as to why this officer articulated this person was in actual physical control. We'll talk about APC here in just a little bit. Using the word because, something that's legally significant, and then using bullet points. That is what we're talking about out here, being reasonable out there. Here's another one. I searched the driver's vehicle for intoxicants because the odor of intoxicants. The driver was coming from a friend's house, which makes it more likely he brought alcohol to the house and retained some of it. That's kind of messed up. Just for a pause there for a second. If you bring booze to someone's house, do you leave it if it's not all consumed, or do you bring it home with you? Let's find out who the cheapos out there. Bring it home with you or leave it to your friend. It depends. Leave it, right? See, look at you guys. So you're good friends out there. Love it, right? The driver didn't pull over immediately, which would indicate he was hesitant to pull over because he knew that there was something his vehicle should not have. His careless parking. Oh, Tanner, I'm keeping my bourbon. Yeah, some high-end bourbon. That might be all right, huh? Parking hastily as the exit from the call could indicate he's trying to distance himself from the car. Unusually talkative, extremely intoxicated, which there could be alcohol nearby. Again, these are all bullet point factors to justify what you're doing. And ooh, George says finish it, right? There you go, right? Cheers, I'm out of here. And then you hop in your Uber. For sure. All right, so we'll talk about this, this idea using bullet points, using this articulation, and this rule of five, right? Striving for five, right? Strive to articulate at least five facts and circumstance for a particular search, a seizure, or a crime. This is an arbitrary number, right? Totally an arbitrary number, but what we've seen and looking and reading all kinds of police reports out there is that if you can come up with five factors, we feel like you're going to have a pretty darn good day in court. All right, you're going to have a pretty good day in evidentiary hearing. Right? You're going to convince other people that you were reasonable and do so. Now, sometimes you've got super factors. You got like that smoking gun. Maybe you only need a couple, or sometimes your stuff is so freaking weak. Maybe you need 10 things. But this arbitrary five, we feel like five is a good number that you can convince other people that what you did was reasonable under the Fourth Amendment. Here's an example. I had reasonable suspicion for the following reasons. The driver gave internally inconsistent answers about travel plans. Right? He kept changing his story. Inconsistent answers about how he knew the passenger beyond his first name. Admitted to recent border crossings. He admitted to drug-related prison sentence of 116 kilos of marijuana. That's a pretty good hit. Extremely nervous, right? It's one thing to be nervous, right? But it's one thing to be abnormally nervous, right? That thing, that neck thumping. We look for that type of stuff. That's good RS for narcotics trafficking. That brings us now to the most powerful word in our police reports. And I know we've got a lot of people out here that attend a lot of our classes. And that word is because. Right? It's the most powerful word out there. And like I said, if you start using the word because in your reports, it's a win for me. And I haven't wasted your time 1 second this morning. It forces you, it compels you to articulate. I patted the person down because I believe this person was under the influence of alcohol because, same thing, under the influence of drugs because. You throw that word in there, things that are legally significant, you are going to articulate more. And like we said, especially my friend Shakespeare said, right? Ye who articulates the most wins. And that at the end of the day is what we want to win. So state your opinion. Should we have our opinions in our police reports? Yes, right? Most of the conclusions that we come up with out there are our opinion. The person's suspicious. That person is, being deceptive. Okay, that's your opinion. Now back it up, right? State because, why, and then articulate facts and circumstances that go with it. That's what the courts are looking for. The blood draw was consensual. Okay, that is a conclusion that the officer came up with, that the blood draw was given by voluntary means. And the DA sent back, hey, I would like a little bit more on this. Why did you come up with this conclusion that the blood draw was consensual? And here's what the officer sent back, and this is what I love about cops, right? Based upon the arrest report and my detailed search of the documents associated with this arrest, there is no information to support the blood draw was not consensual. Did we answer that question? Or did we just kick the can right back? Okay, there's nothing in there to say it wasn't. Well, like we said early on, whose burden is to articulate these things? Is it on us to show the courts that the consent was valid? Yeah, it's totally on us, right? And the officer sent back, there's nothing that says it wasn't. And this is like we said, does the defendant have to prove the blood draw is consensual, or do we have the burden? And as you guys all said here, right? We have the burden, right? We have the burden to show that it was consensual. Okay, the defendant has nothing to prove in this here, and this is especially important when you in the evidence indicates they were uncooperative. Here's some of the paperwork going with that, with the SFSTs. Refused, refused. Also refused. Yep, and refused. Does this appear like an overly compliant person? Not really, right? So you could see why the DA was a little concerned about why it was consent. This is probably what should have been sent back, right? The blood draw was consensual because I read him the DMV admonishment. He told me he understood it. He told me he would submit to a blood draw. And I like this last one a lot here. When the blood draw was taken, he cooperated with medical staff, did not refuse, resist, or complain. Is that articulation? Yes, that's articulation of why this person gave valid consent to jam a needle into his arm. What happened with this case? The DA dumped it, right? The DA dumped it. They're busy. They don't have time to mess around with silliness like that, and they kick that can literally down the road, right? And lastly, here we're talking about using the word because, how important that is, and these two factors here. These two primary requirements for a bulletproof report. If you meet these two factors in your reports, you are going to have a good day in court. One, prove the elements, all the elements, right? Every piece of the element per statute, right? What does your statute say? You've got to meet each and every single part of the element that comes with that. You don't get to pick and choose, right? 2 out of 3, that sounds pretty good, right? That's not the case. Prove each and every element and articulate how you lawfully got your evidence. This is when we talk about our bulletproof report writing book, the framework in this is that, right? Proving the elements, step one. When did it happen? Statute of limitations, we've got to establish that. And location, establishing our jurisdiction. And then the second part of this here, how did you get your evidence? And we teach an acronym out here in blue to gold, and that acronym is what? If you have this, you're being reasonable. What is our blue to gold acronym? There it is. Uh-oh. Amanda, you're getting crazy with the W's this morning. Crew, right? Do you have crew, right? Consent, a recognized exception, or a warrant. And if you have one of these things, at the end of the day, you're being reasonable. And that's essentially how this book is broken down here. It takes that, what is your evidence? All right, cool. How did you lawfully possess it? And then what made it reasonable? What factors allowed you to be where you're standing? You got a plain view observation. What makes you have the right to be, right to see? And that's it. At the end of the day, you prove those two factors, you are going to have a good day in court. All right. Now, let's talk about the law, right? The law when it comes to DUI reports and DUI arrests, right? And there's a few things that we've seen that have come up in some cases for DUI cases, some pre-stop issues out there, and a few of them. One of them comes from this United States Supreme Court case, Wren versus the United States, and this is all about a pretextual stop. And just a little bit of backstory on the Wren case. There were some plainclothes undercover detectives near Washington, D.C. area, and they see a truck with Wren and another guy sitting at a stop sign. And they work narcotics, and they had some hunch that there's something going on with Wren. And Wren sits at the stop sign, and then boom, he takes off. Doesn't use turn signal. I think excessive speed, takes off. And so the officers stop the truck for the traffic violations. Well, as they walk up to the vehicle, again, you can't write this kind of stuff. Wren has crack cocaine in plain view in his hand. Again, you can't write this stuff sometimes. So we go from there, right? And the concern was, like, well, hey, you guys had some pretextual concerns, like you thought something else was going on, but then you use this probable cause to do so. And at the end of the day, the Supreme Court said, yeah, all right, we're good with that. It's actually a unanimous decision in the Wren case. Here's what the courts look at is like objectively, can you objectively do this? Well, can the officers stop Wren for these probable cause traffic violations? The answer is yes, right? Yes, they can. So they don't use this would you test, they use a could you test, right? Could you test? Can you objectively make this stop? Now, of course, it goes without saying, you cannot use pretextual stops for, race or sex or religion, any of this kind of stuff, right? That absolutely is a violation. But criminal hunches and things, objectively, when we look at this, we can do so. All right. Since your subjective mindset, that the court said your subjective mindset is irrelevant. Okay. Defendants may try to argue had no legal authority to stop them. So again, objectively is always going to be our measure in this. So some legal issues that we see out there, right? Do you have the legal authority to make the stop? If you work in an area where there's like, county line, or cities, wherever it may be, there do you have the jurisdictional ability to make that arrest outside of your jurisdiction? Some places yes, some places no. So again, this just, be aware of that type of stuff where you work. You guys should be aware of what kind of authority you guys have in other places. Also, sometimes we've seen where, someone will call and they're like, hey, somebody's weaving all over the place. I think they might be under the influence. And I think they're intoxicated. And this idea of a misdemeanor, committed in your presence. Well, you didn't see those things happen, but they're giving you this information to determine reasonable suspicion, or you see reasonable suspicion out there. Like at the end of the day, you're not stopping that car and immediately citing them. You're articulating reasonable suspicion. And when you look at this, when you look at that, there's you don't have to have an in your presence component to reasonable suspicion. So again, as long as you have those totality factors and suspicions to make that stop, then just again articulate it. And then this idea of stale misdemeanor. Uh, let's say you see a vehicle and they are fail to use turn signal, or don't come to a complete stop at a stop sign, whatever it is. You're like, that's Billy Bob. I'm not gonna mess with him today. 2 days later, you see him. I'm like, you know what? I'm gonna stop him now for that stop sign from a couple days ago. And you walk up there and you can smell odor of alcohol, bloodshot eyes, all this kind of stuff. We're gonna have a problem with that, right? We're gonna have a problem with this being stale, stale misdemeanor. The expectation is that we take action on that now. We don't usually run into a staleness issue with felonies. There's usually more latitude, leeway on this type stuff, but just be cautious, right? You can't use this something that happened a few days ago, misdemeanor, to stop somebody today. We can't hold that in our pocket. So just be aware of that kind of stuff out there. That's some things that we've seen that can be defense strategies out there. Statutes, right? Statutes are important. Again, we talk about knowing each and every one of your elements for the particular crime that you are arresting for. And especially when it comes to DUI, right? It's vital you read and understand your specific state law. Here we teach generalities, best practices, but not state specific. Because again, each state kind of has some different nuances. Like some states you can get a DUI on a bicycle, some states you can't. Some states you can get a DUI on a horse. Some states you can't, which I got to find out what the law is in Missouri. Anybody from Missouri here? Do you guys know that? Not that I'm planning on drinking and riding horses very much. So again, pay attention to your state specific stuff. Horse DUI in Kansas, right? That sounds about right. I'm sure Missouri probably also too, right? So here's our typical law, right? This is typically what we see in the statutes out there. Actually driving the vehicle, right? You see the person driving the vehicle, or actual physical control, APC, and we'll talk about that a little bit more. They're driving a vehicle, and we'll talk about what a vehicle is. Again, it varies from state to state as far as what that actually means. On a public highway or public access while under the influence, right? Oh, good. No, you're good here in Missouri. We only have a Amish here. Be public intoxication. All right, good to know, Jim. Some states allow either or just one. So again, just be particularly aware of, is it driving or is it APC that your state has? So here's an example of the code out of Alabama, right? Driving under the influence of alcohol, controlled substances, etc. Your Honor, the horse was my designated driver, and he was just, pardon the pun, sober as a judge. I like that, Patrick. There you go. I like that angle. Like the horse is my designated driver. There you go. So here it says, right, a person shall not drive or be in actual physical control of any vehicle while there is a 0.08% or more by weight of alcohol in his blood. So there's your limit. Under the influence of alcohol, all right, and we'll talk about this impaired driving investigations. Under the influence of a controlled substance to a degree which renders him, her incapable of safely driving. Under the combined influence of alcohol and a controlled substance to a degree which renders him or her incapable of safely driving, and that impaired driving component there again. Or under the influence of any substance which impairs the mental or physical faculties such a person to a degree which renders him or her incapable of safely driving. Again, there's that the per se limit there, and then you talk about impaired driving. So that kind of encompasses both. So the differences come into play between driving and when you did not observe the vehicle in motion versus like your accident scenes on what burden you're going to have to articulate in your particular state. So there's, like I said, there's two different types of statutes that we see out there: driving and APC. So let's talk about driving. All right, driving, it's the most limited meaning of the statutory terms, right? It's much easier to articulate and prove, right? Many jurisdictions, a person is considered to have been driving only if the person steered or exercised control over the vehicle while it was in motion or intentionally stopped, okay? That is a Westlaw definition of driving, right? In motion, intentionally stopped. So when we look at some driving examples, uh, Sean, I wasn't driving, sir. I was traveling. There you go, traveling on my horse. So some driving examples: coasting a car with the engine off, steering a towed car, pressing a brake light while at a stoplight, driving, move forward an inch, driving, backing into a stall, driving. And these are just some examples of what constitutes driving per statutes here, right? How about this, right? A driver's confession standing alone will not be enough to prove driving under state law. You need additional evidence. This is kind of like this corpus delicti a little bit here, right? You need more than just a person admittance alone, right? What's going on here? Like for example, somebody walks into a police station and they say, you know what, I just killed somebody. Is that enough to convict that person in court? No, definitely probably a reasonable suspicion worthy. At least try to figure out what's going on if somebody's missing, or you can't find their wife or something to that degree. But that corpus delicti, right? Where's the body? Right? Where's the body of this here? You need additional evidence, and that's imperative, right? We've got to do good investigations out there to prove these things. So here's a case that said, after responding to a single car accident, the husband admitted to driving. He was not in the driver's seat. During the investigation, the wife told the officer she was sitting in the middle seat. So this statement by the wife was enough that his statement alone probably not gonna be able to do it, but she now corroborates, hey, I was sitting in the middle seat. That was enough to corroborate his story. Enough circumstantial evidence to uphold this husband's confession to driving. There was more pieces to it. And at the end of the day, when we do these investigations, it takes a good investigation, and you got to put all these pieces together in doing so. Is it enough to ask for a test such as blood breath? So you're talking about, Jim, just solely just the physical or the chemical results. Gosh, I think you got to get at least reasonable suspicion to ask to get to that point, right? You got to get to you through your investigation to get to that point where you're doing so. Yeah, at the end of the day, I think you're probably gonna need some more there, right? So during driving can be proved by circumstantial evidence. Direct evidence is not required. So circumstantial evidence like the seat, hey, it wasn't me, I wasn't driving. The seat is way back and the person's super tall, or the seat's way forward and the person is short. Direct evidence might be I don't know, teeth marks on the steering wheel, and some bloody gums when you look at that. So, again, it all comes down to a good investigation articulating this circumstantial evidence. A suspect was standing next to a car. He was the registered owner. The car was involved in an accident in Mobile, and a witness saw the driver behind the wheel. All right, so when we look at this, are we going to be able to articulate driving? And here's what the court said. It said this was enough circumstantial evidence the arrestee drove the vehicle. Okay, you got witnesses, all these other factors, putting it together, that totality, like we said, and articulation of that circumstantial evidence. Officer observed a bruise on the suspect's left shoulder, right? That's a great thing, right? It showed an indication that, that seatbelt was coming across their shoulder during the accident. That was helped prove the suspect was the driver and wouldn't violate, that corpus delicti, right? That, statement alone, and doing so, good evidence to articulate in your reports. Cops responded to a call of a truck stuck in the mud. They observed an intoxicated occupant in the driver's seat. The occupant was arrested for driving while intoxicated. So, when we look at this, is this going to be enough? And here's what the court said. They said this without more was not enough to support driving. Now, it's a different story, APC, but driving, while intoxicated, the car could not be moved. It's stuck in there. But, what other factors were there that this vehicle, is there anybody else around? How the heck did you get there? Does he have dirt on his shoes? Is it registered to him? There's some other things that you can, articulate in this to articulate driving in this particular circumstance, right? And then we'll move into APC, right? Actual physical control. This one is the more challenging one to articulate. Driving's one thing, but APC is can be a little bit more challenging. So by definition, actual physical control occurs when the person has existing or presently bodily restraint, directing influence, domination, or regulation of the vehicle. That clears it up, right? What exactly, right? And doing so. And so some APC factors, right? When we look at this APC factors here, the person's location and position, right? Where are they? Okay, are they in the car? Are they in the driver's seat, passenger seat, whatever it may be? Inside or outside the vehicle when you make contact with them. A lot of the times when we make contact with people that were involved in an accident, they're no longer in that vehicle. So again, you got to articulate that, if it's your state, you got to articulate driving, or other states, actual physical control. Was the engine running? Were they awake or asleep? Headlights were turned on. So, we look at these factors, can a person that is in a vehicle that's intoxicated with the vehicle running, is there a chance that they are not APC? And there's a chance of it, right? Again, that comes down to the investigation. We've got to articulate how they were in actual physical control, driving that vehicle while intoxicated. Those are what we're looking for when we make these articulations in our reports. So, cops got a call of a female drunk driver. Cops found the car on the side of the road with a male behind the wheel, engine off, female no longer on the scene. So when we look at this, the court said, right, these facts alone did not prove the male drove or had APC of the vehicle. So just the fact alone, if we go back to it here, is, the call was a female, okay, but then we found the car on the side of the road with a male behind it of the wheel. Engine off, female not on scene. Do we have information that he was driving it? Nothing there. And then this APC is like, did he have that dominion, that intent to drive this car? And there weren't those factors in this case, what the courts were looking for. So the most difficult cases is where, it's possible for a person to drove to the parking lot sober, right? They drove to the bar and claims to be sobering up or is waiting for their designated driver, their designated horse to come pick them up, right? So when we look at this, like an example, let's say you go to this from a Nevada case, you go to a wedding, right? You go to a wedding, you're not intended to have too much of a good time, but you do, right? You do have too much of a good time, and you realize, man, I shouldn't be driving. So you go out to sleep it off in your car, right? You go out there and you're sitting there, but you have no intent to drive. You didn't drive there while intoxicated. You became intoxicated, and then you're just there sleeping it off, right? The seats pushed back, your hands are in your pocket. Maybe you've got the heater on because it's a little chilly outside. Those are the questions that we're going to have to articulate out there, is, that dominion and control of that vehicle. So here's some things to look for, right? Engine running, lights turned on, not just your automatic lights, that can be a factor. Do they always come on, or do you have to manually turn it on? Let's say if you have to manually turn it on, that really shows that person's intent to now exercise dominion and control in driving of that, right? Keys, driver's seat, not in the passenger side. We talked about whether or not the, heat or air conditioner needs to be on. Keys in the ignition can always be a factor. Seatbelt fastened. The seatbelt's kind of a good one, right? They put their seatbelt on and they passed out. Well, okay, if you're just there to sleep it off, why'd you have your seatbelt on? Or is it reasonable that these weather conditions are appropriate for what you're saying? Hey, why I need to turn on my stuff? So APC again is just one of those that at the end of the day, you've got to show that dominion, that control, that their intent to exercise that control of that vehicle while intoxicated, right? While intoxicated, because they say at the end of the day, can somebody sleep it off? Yeah, maybe that's the right thing to do. But again, that's the questions we've got to ask of them out there so that we can make that determination at the end of the day. What is a vehicle, right? A vehicle varies from state to state. And again, some states, you can get a DUI on a bicycle. Most you can't. What about the old person on their little rascal cruising down the road, right? So vehicle means every device in, upon, or which any person or property is or may be transported or drawn upon a highway, except devices moved by human power, right? In this by definition. So typically things that have a motor, right? So just be aware of what your statute is. Ooh, riding lawnmower, right? But I need that answer in Missouri too, because I got to get a riding mower. All right. On a highway or public area. Okay, this is another one of the elements, right? Which means the public means access means locations which are open to the general public. Gated communities, businesses are usually included, but not private driveways, backyards, and farms. I think in like Kansas is pretty restrictive on that. And looking at it here, what meets that actual public highway and where it is. And then lastly, while under the influence, okay, under the influence of some sort of altering substance, alcohol, controlled substances, whatever it may be. The two big ways that we usually prove under the influence are blood alcohol content, the BAC, or alcohol affected the defendant, right? Your per se, blood alcohol or your impaired driving theory. So to a degree that renders them incapable of safely driving or exercising actual physical control of the vehicle. So virtually every state provides that the slightest impairment of the ability to drive is safely sufficient. People can be impaired under the legal limit. It just depends on how their body has a tolerance for it or whatever it may be. When we look at this, as long as you can articulate that impairment, that is part of your elements. However, you still need evidence, right? You can't just you still gotta conduct your field sobriety test. You gotta articulate that they're driving, or APC, that their driving was affected. And again, that's why we do our HGN. That's why we do our field sobriety test, walk and turn type stuff. So those are things that always pay attention to in your statutes. All right, moving into our DUI investigations, like transitioning from a traffic stop for a lane change violation or fail to come to a complete stop, and then moving into a DUI investigation. But yeah, at the end of the day, the question, at the end of the day is like, should you say, hey, I don't think you are DUI? I think that guy loses that case right there. I pulled you over, I had reasonable suspicion thinking you were DUI, and then I immediately tell you, I don't think you are. I think that could be a problem for us for sure. We don't we don't want to say that. What was the biggest trouble out there for my trooper friends out there? What did he do with that hat? Chucked the smoky, and that we can't have, right? You need reasonable suspicion to ask a person to conduct a field sobriety test, right? When we look at this, you've got to have RS out there, at least again, that moderate chance of criminal activity taking place. So this also is another great takeaway from our report writing classes, using the word because, meeting all your elements, articulating how you got all your evidence, and articulate exactly when you transition a traffic stop into an investigative detention using bullet points. What we mean by this is, essentially this, based on the totality of the circumstances, I had reasonable suspicion at approximately 125 hours that the driver was driving while intoxicated for the following reasons. And then you go on. Here's your bullet points, right? The driver failed to maintain his travel lane 3 times. He followed another vehicle at a distance probably 25 feet at 60 miles an hour. I smelled the odor of intoxicating beverage emanating from the vehicle and or the driver. The driver admitted he consumed 2 beers before driving. Therefore, I transitioned stop to a DUI investigation. This This right here is you're telling the courts what's going on. You're telling them why I now have a reasonable suspicion to continue this stop for suspicions of under the influence of drugs or alcohol. You know, don't have them, don't force them to extract it. Be on point. Get ahead of that and say, hey, here's what I've got going on out here. Here is an example of a DUI. Let's look at this guy and see if we could articulate some of these factors we're talking about.
Okay. All right.
Good evening.
Hello. Whose car is this?
It's mine.
Okay. So what happened?
I went to make the turn, and then as I was making the turn, I rear-ended them right about here.
What turn? Where were you?
This one, right about from this street. I was making the right, and then as I was going on,
you make it right onto here?
Yeah.
Okay. And then you hit the rear end of the car?
Yeah. I braked first, and then I tried to brake, but I rear-ended them, and yeah.
All right. What about the damage on the side over here?
That was before. That was from a bus from probably last October.
Last October. So that didn't happen today?
No.
No.
No. It happened months before.
Okay. All right. And need your driver's license, registration, and insurance.
Sure. My license.
Uh-huh.
Um, so what do you think? How can we prove he drove? Give me some stuff out there. Well, how are we gonna prove he drove, right? Driving or actual APC, right? I love the fact that, like I say, what's up with this damage here? Oh, that's from last time I was drunk, right? So again, just some big factors in this one. Standing near the car, admits it's his, no other apparent means of arriving on scene. That's something that sometimes we don't always articulate in there. Witnesses are there that'll put him as the driver. He doesn't deny driving. He actually tells you about it. He can explain prior damage. All good things here. Now, what about impairment? How long are we gonna hang out and wait for that ID to come out? Do you think it's ever you think it's ever coming out of that wallet? Slurred, slow speech, swaying, blank stare. The lighting, maybe that's something to articulate that good. There's good ambient lighting out there, fumbling with his wallet, drooping eyelids, uh, incomplete sentences. Again, all kinds of stuff out there. Let's talk Miranda here for a little bit here. When we are conducting an investigation, right, and we're doing our field sobriety test, and we're asking someone, hey, how much did you have to drink tonight? And they are not in arrest-like custody. Do we have to read a Miranda? The no's have it. There we go. All right. The no's have it, right? Miranda only applies when there's arrest-like custody, like handcuffs, in the back seat of the car for transportation. Again, at the end of the day, the courts are looking for, right, this arrest-like custody. More than just not free to leave, arrest-like custody. That's what we're talking about here, right? So an officer detained a driver in handcuffs, placed him in the back of a police car. Another officer arrived and took off the handcuffs, asked him about drug consumption. What do you think? What the court said, right? The court said the drug statement suppressed because this was arrest-like custody. They put him in handcuffs. They stuck him in the car. And I don't think they did enough in this case without getting the real details of this case to take the sting. I would say we talked this taking the sting out of it. That's the wolf that lives in my house here, right? Telling the driver he's not in custody before these tests will help this, right? If that's the case where he's already been stuffed in the car in handcuffs, now you're taking him out, then maybe you try to clean that up a little bit, right? Try to clean up, hey, you're not under arrest right now. Here's why you were detained earlier. And you can try to take the sting out of that third component, right? You've got to have what? arrest like custody, known police officer, and you're asking questions that are likely to elicit incriminating responses. So that is our three parts in this. So the courts felt that this one's still too much arrest like custody without cleaning it up a little bit more, right? An officer asked an apparently intoxicated driver whether he drank or consumed drugs. He admitted that he did, and his statements were used against him. Again, if this is not arrest like custody, can we ask questions like that? Yes. There you go, right? Yes, 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 right? Hey Sean, anytime the cuffs go on, that's definitely a big factor when it comes to this here, and detainment, and those are things to be aware of. Again, if they're not under arrest, and if true, you can, use these Beheeler type statements, say, hey, you're not under arrest, but here's why you're doing so. Again, there's always going to be that measure of arrest-like custody, right? So constricting that a reasonable person would think that, hey, man, I'm going to jail, right? The driver was not in custody, even though not free to leave in that the Berkemer case, right? So again, we can ask those kind of questions. This is kind of an interesting side note, though, when it comes to Miranda, right? Only applies to testimonial evidence, right? What you thinking about, right? What your mindset is here for a person to testify, right? Incriminating responses, not physical evidence like FST performance. And what we mean by this is an in custody driver. So we've got arrest like custody, known officer, and we're asking them incriminating questions, was asked to perform field sobriety tests without Miranda. Well, this is kind of an interesting outcome because the court said the HGN test was not testimonial. So just doing this and your eyeballs moving around wasn't testimonial. However, the court did say her performance under Romberg was. And the reason why they said this was a problem with Miranda is you got to think about it, right? There's a testimonial component to this where you put your head back and you got to estimate and think about how much time's going by. Kind of an interesting outcome on this as far as testimonial evidence when it comes from Miranda. So just the bottom line is pro tip: even if you plan to arrest the driver after field sobriety tests, it's irrelevant as long as it's not communicated. You walk up to that car and you're like, damn, this person is going to jail. As long as you don't communicate that information with them, as long as you don't tell them there, then you don't have to read Miranda, right? Again, that it's subjective at that point in time. You can still ask questions outside of Miranda. All right, and last we'll jump into some trial strategies here. So I'm trying to crank through this. I apologize for talking so fast. So defense attorneys will try to impeach you, right? They'll try to impeach you on the stand so that you are, your credibility is shot out there, and they can't use this type of stuff. So they will actually, some defense attorneys, these high-paid, especially DUI lawyers, will have a folder on cops out there, and they'll look for similar statements. They'll look for, blanket type stuff. They'll look for template type stuff in our reports. And they'll show that, hey, every time you say this and every time it seems like you've seen this, and they can use that to try to use that against you in court. Now, templates can be fine, but just save them as a read only, right? Save them as read only so you don't accidentally have a plate from a previous arrest or a name or a person from a previous arrest. You can use it as an outline function, but please make sure that it's always specific and individualized is what you're talking about, right? And we look at another exhibit here, write individual reports, not generic cut and paste templates. I saw a report not too long ago where a report had one person's name in another person's report, and they end up dropping both cases, right? We'll skip over this video. Talk about cut and paste, right? The cops were cut and pasting, and again, that became an issue. Here's from a DUI attorney that makes good money doing this here. And he said, although it also the case that even honest and conscientious officers tend to observe many of the same symptoms, like we see and we look for the same things out there, and describe them in an identical language, evidence of a carbon copy report can be devastating. Jurors find it very interesting the officer on the stand always observes a suspect, for example, travel at 70 miles per hour, cross into the number 2 lane for 2 seconds, and then back into the number 1 lane, right? Again, you don't want to carbon copy stuff. You want to always be specific and individualized about what's going on out there, right? We've seen this too. Hey, officer, isn't it true you got overtime for this DUI arrest? Are you getting paid extra to do this here? And if that's the case, so be it, right? But the quick way to shut this down is, well, yeah, if you got OT, sure, but I've also made plenty of arrests during my working hours, right? This one just happened to have towards the end of the day and carried over. So really, again, defense attorneys are just trying to make it look like you're just some incentivized to do this type stuff, or things like this. You receive DUI awards for doing this, right? Maybe you get like some cool pins on your shoulder for every DUI arrest you get, or oh, it's like was it Ohio State, right? You get stickers on your car for every DUI arrest that you make out there, for sure. So, you look at this, like if the defense tries to imply that you're getting a bonus for this or whatever, that you're motivated to make sketchy DUI arrests, like, yeah, it's kind of marginal, but hey, I'll get another sticker on my car because of the DUI award. Essentially, just respond to that. You're only motivated to save lives ruined by drunk drivers, and just matter of fact, right? Matter of fact, no, this is why I do it. No facetiousness in it, no arrogance in it. No, I make these arrests because I know the outcome that can take place, right? Just kind of shut these things down and quash it real quick, right? Inaccurate environmental things, you didn't quite, you didn't explain that as 90-mile-an-hour winds outside, or the fact that your camera, you've got your body worn camera, sometimes you may be too close, or if you've got a camera in your vehicle, is it pointed where you conducted the field sobriety test? And if it's not, why? If you can move it, again, just things that you can do to get ahead of these things, answer those questions, or do it so that doesn't become an issue on the stand. All right. Man, that was a lot of information. I hope you guys found this stuff informational. Please leave us a review out there. We'll jump into some trivia here in a second. Thank you all for being here. Appreciate y'all. These DUI investigations, are so important, but they can be a little bit convoluted. It really, again, it comes down to that articulation, the investigation, knowing your elements, and then proving how you got your evidence in there, for sure. So please always check us out at Blue to Gold here. I'm going to stop the recording. You guys want to hang out? We'll do a couple of quick trivia things here. Teresa's sending out all kinds of links out there. Please check us out on our social medias. We do these webinars about once a week. Most of the time we do the Search and Seizure show. So appreciate y'all. If you guys want to hang out, we'll do some trivia with that. Thank you guys all. Be safe out there and take care.